The Wild Creatures and Forest Laws Act of 1971 might be mine, just because it's absolutely insane, and also because it keeps the name verderer on the statute book, which also I think should be something to do. And it has a book relating to it, which is significantly longer than the Act itself. That, however, is not what I'm talking about. I'm happy to take questions about such of the Law Commission's project as I can or feel able to comment on it. I was the lead lawyer for the Law Commission on that project up until about a month and a bit ago. I now work for DEC. I have a reasonable amount of room for manoeuvre, I guess, relating to work which I've previously done. I obviously cannot be drawn into certain discussions of a political nature, but you all know this, so you're not going to ask those questions, are you? Good. Right. What I am going to talk about...
Do you want me to...
No. Do you know one of those?
We don't know if a clicker, actually. So.
Oh, in which case, yes, I would love it if you did that, but not yet. We should come up with some sequence.
Yeah,
I had a colleague when I used to teach in Belfast who used to wear a big hat, and he said, look, I appreciate students, you're not going to concentrate on me all the time, so I will lift my hat every time I'm going to say something that you want that is of interest. The rest of the time you can just sleep through my lecture, because you're going to anyway, so I'll just go like this, and maybe some of us will stay away.
That's a jaundiced view of the university life.
And inaccurate?
That's what I said.
Right. I'm not going to talk actually about the sort of what you could describe as the substance of wildlife law, that is, that which is prohibited or allowed within a common framework. So the protection of habitats or the protection of species, partly because other people will, and partly because I've spent 3 years doing that. I'm going to actually speak about something which was out with the Law Commission's major considerations, which was access to justice. So this is the ability, not in relation to me being imposed with a crime, but how I enforce, or more importantly, how NGOs in this area enforce decision-making as it pertains to wildlife or the environment. So it's a slightly different thing. So it is more about the structure of a future regime as opposed to the actual, can I kill A or B or C, and what will be the penalty for it for me if I do that. Click. Click. Really, we're talking here about the challenge to administrative action. Or a challenge, which could be a challenge to a law, or a set of regulations, or it could be a challenge to a decision made under a set of regulations. The approximate location for most of that, as far as we are concerned in the United Kingdom, is by way of an application for judicial review. For those of you who this is boring repetition, I'm very sorry. But essentially this is an action where certain classes of people, those people with a sufficient interest, can bring an action challenging a decision. So what you need is a sufficient interest and you need a decision. Once you've got those things, then you can bring an action. Up until mid-1980s, that really meant a person. So a person to whom a decision was addressed. I might advise you in your free time, and this is slightly outside my talk, to consider the way that environmental law may be going as to challengeability of decisions where there is not an individual recipient. Because there are changes being planned relating to the scope of judicial review, or the availability of judicial review, which are currently before Parliament. So for those who are interested in this, the Criminal Justice and Courts Bill 2014 has some interesting sections at clauses 52 to 59 for those of you who are geeky about this sort of thing. I'm obviously not, so I didn't know those numbers. Judicial review. I need sufficient interest. It never used to include others. It used to be had to be a person. And environmental groups found exciting ways to get around that problem, so they found a member who was resident near, say, Sellafield, and therefore the claim was brought essentially by the NGO, but in right of its members who happened to be living in Cumbria. It's an interesting way of going about it, and the court has moved on since that. Within this area, we also have to consider the way that standing works for tribunals, which is not exactly the same as the judicial review. Judicial review has a particular test. Tribunals are a creature of statute in a much more simplistic sense, and therefore you need to give someone something which they can fix their right on. So you have to specifically extend something to a legal body for them to be able to use a tribunal. You can do this by reference to an existing piece of law, or you can ascribe it specifically in the measure giving the access to the tribunal or founding the tribunal. However, you need something, and if it is not there, the person does not, or the person, group, body, or whatever it is, doesn't have the right of access. So it is important, even more so, arguably, for the purposes of tribunals. There's less inherent jurisdiction. Okay. Badgers don't get to bring cases. I think that's probably where I'm going to go with this one, but nothing does. Which is a slightly throwaway comment for something which is actually really important. Environmental law and environmental matters, especially at the sort of structural and complicated end, tends to be an area where individuals don't litigate particularly well or successfully. One is because of information flows and the scientific nature, and just the cost. Now, cost is something we're going to come back to, but in that litigation in the United Kingdom is expensive. But even if the occasional lawyer wasn't quite well paid, it would still be complicated and expensive, because it is an area where there is high scientific input. There's a significant amount of technical data. There's a significant time flow in it. This is not a stand up and challenge decision. Now, immigration is very, very complicated and very, very important. Housing rights are very complicated and very, very important. They don't tend to, as cases run for 10 years. We will be debating Hinckley for quite a long time. It is the length, the amount of commitment and time and process doesn't lend itself to individual litigation. It can, and we will come across a couple of people as we go through this, where they have pursued it, and there are the occasional litigants. But as a general rule, the structure of the area lends itself to NGOs bringing claims, not necessarily to individuals. So it is important. Then we have the next. Now, I really don't mind how you say this one. I believe the correct pronunciation is Aarhus. Just about everyone refers to it as Aarhus, but I tend to say that I'm going to Paris, not Paris. But actually, I quite like the sound of Aarhus, so we're going to go with this. Anyway, this is the UNECE Convention on Access to Information, Public Participation in Decision Making, and Access to Justice in Environmental Matters. You can now see why we tend to refer to it as the Aarhus Convention, or Aarhus, because otherwise everyone would have gone home before you get to the end of the name. It is not an EU agreement. It is a UNECE agreement, so a UN body existing here. Consequently, the EU doesn't naturally, or isn't naturally a member, so it is a member only because it is signed to it. So it is, for those of you who like this technical thing, it is a mixed agreement, which means that competence relating to it is shared between member states and the EU. There are certain matters within the Aarhus Convention which will be exclusive to the Union, and there are certain matters, normally relating to the allocation of land, which are exclusive to member states. So, consequently, to enforce the complete rights inherent in the Aarhus Convention, you need both the EU and member states to be a member for so long as we remain members of the EU, however long that is. It's basically a simple but incredibly important treaty. It grants rights. It grants rights relating to the ability to get things which you need if you are going to challenge environmental matters. As I said, this is an incredibly complicated area, and the decision maker frequently holds a lot of the information, and anyone challenging the decision needs access to that information before they can maintain a challenge. Because otherwise you don't have the grounds for the challenge, so you need the science, and you need the decision, and you need the basis on which the decisions were made. Otherwise you are pretty much out in the dark in this area. So the first part of Aarhus, which is the access to information, is actually arguably the most important part of it, which is a shame because I'm talking about the third. This isn't because I don't want to talk about freedom of information, but freedom of information will take us significantly longer than the 20 minutes that I have, but we do get to use the term client earth. It's a floor, not a ceiling. It establishes basic rights. Member states can go further. The only way that you could ever go to the wrong side of that is if your environmental protection was such that it distorted the functioning of the internal market. The chances of you doing that in relation to freedom of information are so infinitesimal that you don't really worry about. But that's about the only way that you're going to run into a ceiling problem. Everything else is going to be a political decision, or a decision taken on rights within a constitution or within a general framework. The click, 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 click. Sorry, all good. It's my favourite fault. I would. Right.
I'll follow you.
There are two ways into Article 9 relates to your ability to challenge decisions and to protect rights pertaining to the environment. There are two ways that people have a way in, and it is split slightly as to the nature of the project. Article 6 projects of those listed and have a significant impact. There is a list of specific projects. There are obvious ones, so as you can imagine, large-scale mining, for instance, would get in. Because it is a UN and applicable over the EU convention, it had to deal with the fact that there are different ways that people construct laws. So, as I said earlier, in the United Kingdom, we base our access to judicial review on the idea of a person having a sufficient interest. That is not true for all states across Europe, and a lot of other states, especially the sort of more continental classic Roman tradition, would take it about the impairment of a right. So I have a right to do something, my right has been impaired, and therefore I have an ability dependent on that right to challenge the decision which impaired the right. Makes sense. To do this, there are two ways into Aarhus, and therefore it takes those. As far as we're concerned, we're quite lucky on this because the ground, sufficient interest, is exactly the same as the ground which exists in JR. However, it does have to include NGOs, which we will return to later. And the most important, and the next one, because I've noticed that I'm taking more time than I want. Procedures shall provide adequate and effective remedies, so you need to be able to get something at the end of it, including injunctive relief, so you should be able to stop something. The RSPB case is probably the greatest example of why you need injunctive relief, which is the building, it's Lapel Bank, the building of chairs, the extension of the Port of Sheerness, which is all very well, but it made it to the Court of Justice. By the time litigation was finished, there was no Lapel Bank, but quite a large port. So you need something. Everything should be fair, equitable, timely, and not prohibitively expensive. Prohibitively expensive is a phrase which I want you to hold on to. Now, can we go on? Right. There is a prize for the person who can pronounce that correctly. I'm not going to even try. We are going to refer to that as the Slovak brown bear case, because I can say that. This is relatively simple. This case concerns, strangely enough, so about brown bears, but it's also about how and to what extent the Aarhus Convention relates to EU law. Now, Aarhus is a mixed agreement. You have to sign, you have to transpose, and you have to bring it within EU law. So what happened with this is that the EU has signed and then it has brought it in, but it is mainly brought it in through amendments to specific directives, for instance the EIA directive. So the Environmental Impact Assessment Directive was amended post Aarhus to take into account increased rights to access to justice. This is a continual arc that we'll get to. I've got 10 minutes, haven't I?
About 8.
Good. This is a continual arc. Now that's fine, but this was a case concerning majorly a decision relating to the Habitats Directive. The Habitats Directive, strangely enough, has not been amended. So the query is, what is the relationship between Aarhus and the general principles of EU law? So if I am, for instance, in this case, the applicant was an interest group, do I have the same or related standing as I would have under Aarhus than I would, that I should if I were bringing a case, for instance, under the EIA directive? So how much do you trace across? The British Advocate General said that you don't, quite simply, and almost certainly at a very legal level correctly. There is when the EU signed and ratified its part of the Aarhus Convention, it entered a declaration limiting the sovereignty of the EU to certain matters which were already within the scope of EU law, so effectively it's limited it to things like the EI directive. The court took that as indicative and then ignored it, and said that Aarhus and the principles in it form part of the corpus of EU law, and therefore you have to look at older part of EU law to get what they are saying here. The Court of Justice started off its life because it was bored. It was incredibly bored for the first 5 years of its life. It didn't really do anything. Allegedly, when they got their first ever reference, they cracked champagne in the judge's room because they hadn't done anything for the first 5 years other than staff cases. And they get around this by granting EU law rights inside domestic law, and the part of that was to increase the protection of EU law because essentially the court didn't trust the other mechanisms present in the treaties, for instance interstate cases, of which we've been one, actually no, it's never been a full one, and commission infractions. So where we get sued by the Commission for having not transposed laws. But that didn't provide sufficient protection. So the court relies on individuals and people and things bringing cases to enforce what it regards as EU rights. For that to work, you have to take, and this is what the court said in Slovak Roundtable, you have to take an expansive or who's compliant view of what is a person able to bring a case, and that means NGOs, because otherwise you would not get the protection of EU law, EU environmental law, if you merely relied on cases brought by private parties. So it specifically extends the protection of EU environmental rights to include NGOs. Now that's fine, because in a way, so there was a relatively easy case. It caused all kinds of hell when it was produced, but if you think about it as classic EU law, so granting of rights to ensure the enforceability of EU law, then it kind of fits within it. The next case, Trienal. We tend to know this. This is a licensing regime for a coal-fired power station. Now, there is an existing law in Germany. The existing law relies on a person having a right which can be impaired. Unfortunately, for the purposes of that law, NGOs can't have rights which can be impaired. So therefore NGOs don't have access. The court dealt with this what can only be considered as swiftly. Say, well, that doesn't make any difference. You need effective enforcement. So you have to be consistent with the principles of Aarhus when imposing or applying your national law. So therefore, a right, for the purposes of impairment of right, has to include the potential for an NGO to bring an action. So it can't merely be limited to rights which can be held solely by an individual or natural person. So again, it draws a wider version of what is a right and what is a protection. So the relationship between environmental law and rights was essentially what the court was playing with in that case. And again, this is quite important because, as you can imagine, we might have a slight problem if someone rewrote all of the rules for judicial review in the United Kingdom. This is essentially what the court was doing to German judicial review for environmental matters. It's okay, so they're also doing the same for us. Costs. We are an expensive place to litigate, I think is the best way of putting it. There will be good reasons for this, and we don't need to Now, Edwards, which isn't really about Edwards. Edwards was the party who dropped out of it. It's actually about someone else. Now, this person was resisting the imposition of what they regarded as a bad cost cap. So they were required £25,000 should be paid, and they thought this was prohibitively expensive. And the result of that was that this made two trips to the Supreme Court and one trip to the Court of Justice. And ultimately failed, actually. It didn't fail on the legal ground. It succeeded on the fact that the Court of Justice held that litigation in relation to environmental matters should not be prohibitively expensive. And this applied in that case. The effect of this has been that we are having to rethink, or have once rethought, and will have to be thinking again, the cost rules applied for litigation within the United Kingdom. I say we have thought about it once because post-Edwards, coming down from the Court of Justice, there was a new cost regime set which approximately limited cap litigation at the £30,000, £5,000 and £35,000, £30,000 depending on which way you're going. But actually that's going to have to be rethought, because at the same time as Edwards going through, the Commission decided to infract the United Kingdom on the cost of litigation in the United Kingdom. And this one's slightly more worrying, or if you are concerned about this sort of thing. It's probably right, though. In the final case, Commission in the UK, the Court of Justice handed down a ruling following a very, very strong opinion from the Advocate General to say that almost any number doesn't work, because you have to take into account the features of the litigant, and that the litigant for this purposes is the NGO. So you need to have a rule which is flexible enough to allow access to all, providing they are bringing a reasonable case. And consequently, a £30,000 cost rule, or almost whatever £5,000 cost rule would not necessarily work, and one has to therefore think a little bit further about the flexibility available in the rule. There is normally discretion to dispense with this, but there is an argument to say that discretion can also act as a barrier. So more thinking to be done on this one, I think. Where the MJ is going with this, I don't know, and I can't, even if I did, I couldn't comment. But I want you to think about, what I'm trying to get across is that there are these debates going forward, and one has to think about how the machinery around the pretty little law in the middle looks and works and involves people. And this is where we go to the last bit. That's fine. Possibly the most litigated directive ever is the EIA directive, and it's definitely one which has been the most manufactured by the Court of Justice. So there was an EIA directive in '85, it has subsequently been amended twice, consolidated once, and is now in the process of being amended again. Well, actually the consolidation is being amended. At 3 years, that does not make that the longest ever consolidation. The story in this is that the Court of Justice has played very, very firmly with expanding access to environmental impact assessments and ensuring the freedom of information, provision of information in relation to environmental impact assessments. And the effect of that has actually been that a lot of that is now being solidified from case law into hard law within the directives themselves. So it's quite an interesting picture on how a piece of judicial lawmaking on part of the court can become crystallised into protection for individuals and for freedom of information. The new directive, which has just been published, won't come into force but won't be due for transposition for another 2 years, will require greater provision of freedom of information and, more importantly for the subject matter of this debate, does something very, very useful. Up until this instrument, only by case law were things like the Birds Directive and the Habitats Directive aligned with the EIA directive, in that they were drafted in a slightly different way, and consequently they didn't align properly as to what you had to show or not show in relation to an impact assessment and the way that one mitigates effects as to, for instance, nature, as opposed to obligations under the Habs and Birds. The 2014 EIA directive will align those two regimes, thereby allowing finally someone to be able to create a sensible system, which would be good, because where we started, and with what Angus was saying at the start, is that we have too many different regimes and too many different ways of thinking about what is frequently the same problem. And part of that hasn't been caused always by us passing a Badgers Act, but occasionally the base regulations or the base directives at the EU level haven't been aligned either. So I put this one in because it helps think about how the other parts of the regime are starting to align, which would be quite useful for creating a wildlife law and an environmental law which actually works and is fit for purpose. Thank you.
Yeah, any questions? Before Keith goes anywhere.
Hi.
Any questions?
Blind.
I knew Mark had probably one. Yep.
I
have one.
I
Holding on to
promise
it.
all the way. Our house is our house, whatever it is.
The problem with saying our house is that I have madness in my head for the rest of the bloody day. It is always.
It's interesting, and I promised all the way down here that I wouldn't mention the word, the badger word. And here I am mentioning it already. But what the whole issue, the badger issue, which has been troubling me for a long time, has done is brought to light a number of legal issues which are being explored through various mechanisms like complaints to firm or judicial review proceedings or whatever. And one of the things that has been suggested by us is that there may be an issue with the sort of indirect impact of removing large numbers of an animal, large proportion of an animal like a badger on other protected species within an ecosystem. Now, would that come under cost protection, under Angus if you brought an action?
I don't think there's any possible way I can comment on this one because I need to think about it. And
Yeah.
two, because even if I could, I think we're being taped.
Do you want to think about it? We may come back to that in
I mean, maybe
the
the
discussion.
principle of interventions which may have secondary or indirect impacts. I mean, all interventions have impacts. They obviously have sort of primary impacts on the animals that you intervene with, or plants, or whatever it is. But they're also going to have all kinds of secondary impacts or indirect impacts because ecosystems are complicated.
Yes.
And things like badgers in the UK are, relatively high up the pyramid.
No, I take the point. I mean, if you're talking about if something relating to badgers, if you're challenging that, obviously is within the scope, because environment is drawn so widely for the purposes of the Aarhus Convention itself. It's actually quite tricky to get outside their definition of environmental matter. I mean, obviously this isn't a project for the purposes of Article 6, but the Article 9.3 part of it relates to other things, which, so at that point you would probably be maintaining, you would probably be within the scope of Aarhus at that point. I say this off the top of my head because I have...
Possible challenge from the gentleman?
Well, no, I was just thinking that, I mean, the project that led to it would be challengeable within our rules. So, because that's certainly a project, the thing that led to the removal of the badges in the first place. So I think you could probably...
Which would make it an Article 6. I wasn't sure that it was an Article 6, but I thought that it would be an Article 9.3, whatever happened.
I think, like you, I think certainly 9, I think it could be 6 as well. Depends how you dressed up your challenge, I guess, but I think it's a good chance of getting it.
Either way...
For the non-lawyers in the room, bear with us.
either way, the rule on non-prohibitively restrictively prohibited
In terms of cost,
is applied, because that bites on both 9.2 and 9.3.
But you, if I follow you, well, I sort of do, you believe then, I think from what you're saying, that it's going to be actually easier for NGOs to challenge wildlife decisions in the future?
I don't know. Because I don't know which way we are going to go.
Sorry, I meant within the context of EU law.
If I know which way the court is going,
yeah,
and that I can comment on, I don't know what will happen to rules in the United Kingdom which might lead to a series of essentially collateral challenges. Both to, well actually in a couple of cases, either direct challenges going to the Court of Justice or challenges going... the Aarhus Convention has a compliance complaints committee, so things can be lodged against that or whatever, but unfortunately they're only binding in international law. So don't have the same effect as EU law within here, but I can add, there is a definite drift in EU before the Court of Justice to expand as much as it can access to justice in environmental matters, because it really is very worried, I think, about the protection that has been afforded through other mechanisms to environmental matters, and it has gone in its own, and it says it in Slovak bound there, it has gone effectively on record as saying that it doesn't think that there is sufficient protection of its own directives.
Yeah.
So, of EU core Habs and Birds directives.
Okay. Any other questions, Keith? No? Well, thank you.